Hey, welcome everybody. Back of my head, just so that's always scary when you do that. Like you don't know that's what it looks like. So today, um, dual agency, transaction coordinator, and a couple other what I'll call agency updates, things that we just need to be or should be aware of. So here we go. Let's get it rolling. You got questions? Let me know. Work for me. I probably got to do this first. There we go. So there's this case that happened out in New Jersey, and as it says here, the agent was working as a buyer's agent for buyers who became interested in a home that was not listed. So basically, we know FSBO. The agent contacted the owner. The owner signed a listing agreement, and immediately both sellers and buyers then signed a dual agency agreement. So just to be clear, the agent already representing the buyer talked to the seller says sure, and they went ahead and signed a listing agreement and then properly followed up immediately with the dual agency agreement, disclosure that agency relationship had changed, they're now dual agents. So as the buyer and the seller are working along, they had disputes. Surprise, surprise. Eventually, the deal actually fell apart because the agent just couldn't keep the two parties together. The interesting part is the seller then sues the agent and claimed that the agent, while the agent agreed to act as a dual agent, she was, quote, acting 99.9% in favor of the buyers. So here's what we want you to know. In this particular case, the agent won the case, but did she? Because she was required to hire an attorney to defend herself in as far as the litigation. I believe, regardless of which side of the house you're on, you're going to pay about $5,000 to have yourself represented, because that's the first part of, our errors and omissions. So just because she won, she still lost. So where are we taking this? The lesson from it is simply this. What we know is serving as a dual agent, it's actually extremely difficult to do. You're not there as a mediator, rather the role is simply to facilitate the transaction. We know that we can't disclose anything confidentially about either party that could harm either party's negotiating position. We can't work in favor of one over another. So the role basically is impossible if the relationship between the buyer and the seller becomes toxic or they have issues. So outside of dual agency, if a dispute arises as a listing agent, we could walk the sellers through their options, but that becomes difficult when you're acting as a dual agent. So any comment you make as an agent that is not aligned with the seller's view, they're probably going to interpret that you are taking the buyer's side, which was the circumstance in this particular case. So the bottom line, I always think of it this way, and transaction coordinator comes along with that, but here's what we know. Either one of those, you're essentially walking on a fence. You're walking on a fence. So eventually you're going to fall to one side or the other. And then all of a sudden you've become that direction that you fell. So we have to walk very, very carefully, especially as a transaction coordinator. One of the messages I'll give you today is, I don't think you should ever be a transaction coordinator. Don't ever become a transaction coordinator. What we're really talking about is represent one party whenever possible. So I want to introduce you to the aspect of a one-party commission agreement, not a one-party listing, but a one-party commission agreement. So what this does is to help us avoid dual agency or being a transaction coordinator. So even to the point of when a seller comes to us and says, hey, we've put this deal together with a buyer, or the buyer comes to you and says, hey, I put this deal together with for sale by owner. Can you handle the transaction? Often what we want to do is represent neither party. Now I say that's what we've often done. I'm going to discourage you from doing that because transaction coordinator, I neither represent the seller nor the buyer. I don't represent either one. And yet there you are on that proverbial fence, not having or trying to not lean one side or the other. And that's extremely difficult. So if we're dealing with a for sale by owner and we have the buyers in this case, whom we already represent, whom we contacted the for sale by owner on behalf of, we need not create dual agency by signing a one-party agreement, listing agreement. We don't need to do that. Yet we can guarantee our income and the seller's willing to participate by putting together this one-party commission agreement. So if the agent already represents the buyer, there's no need to create that by entering into a listing agreement with the seller. We can do this one-party commission agreement as opposed to a one-party listing agreement, which allows us to align ourselves with only the client whom we started with. In the scenario that we've got, we were already representing the buyer. We don't have to represent the seller. And we still have our guarantee of payment by entering into this one-party commission agreement. What do you use? The MR Form N. And here's the beauty to this particular form. It will work for either the one-party listing agreement or as a one-party commission agreement. Now, I will let you know, blue or gold, it's in the listing package now. If you go to the main package for Coldwell Banker or the main package for Century 21, it's in there. Okay? Probably, I think it's the second to last document. I've even put in there the 295 and 4%. Why not? Ask for it. What the heck? Read the agreement, guys. You'll see how it works and why it can go either way. But if you don't understand it, reach out to me. I'm sure your manager or broker will be able to help you out with that. But it gives you that aspect to where I can get my commission, disclose to the seller that they're on their own, that I do represent the buyer. It'll also get into the aspect of lead-based paint, being able to, whether or not they have to disclose that. But it's all there. It's in the package. And if you can't find it there, just know it's a MAR form, Michigan Realtors, the MR. And let's see. So here's what we know. If you're using a one-party commission agreement, be sure to work straight and square within what the terms of the agreements are that you have done. Stay within that framework. An unrepresented seller or buyer should be encouraged to actually seek legal and counsel. Now, that's part of our purchase agreement. But I think just, you know, Mr. and Ms. Seller, I do need to tell you that you should. Okay? Doesn't mean you need to. It's up to you, but I do represent the buyer. Do not create, and this is going to lead somewhere here quickly, do not create the appearance of an agency relationship with the seller. Remember that an agency relationship doesn't require a written agreement. Wipe out in parentheses. You don't need a written agreement. You'll go back to pre-license training. It's called implied agency. My words, my actions can imply agency. Matter of fact, let's go in that direction. So here's another case for you. Hall and Shields. They entered into a purchase agreement to buy vacant land. They were represented by an agent, and at the time of the purchase agreement was signed, the seller actually provided the seller's disclosure statement, which disclosed the existence of 2 oil wells that were on the property. Well, when that happened, Mr. Payne steps up and jumps in Shields' position. So Shields says, I'm out. And the purchase agreement was amended to provide that the buyers would be Payne and Hall rather than Hall and Shields. The agent continued to represent the buyers in the transaction. So the same agent stayed there. This is kind of familiar because we've done this where we've had a buyer removed from a purchase agreement, maybe another person put into the purchase agreement. Anyway, after the closing, Hall and Payne discovered significant environmental and safety issues with the old oil wells. So Mr. Payne, I changed his spelling unintentionally, but it actually works. Mr. Payne sued Mr. Hall for failing to provide him with a copy of the seller's disclosure statement, which disclosed the existence of the wells. So the court threw out Payne's lawsuit against Hall because the agent, who was also Payne's agent, had known about the seller's disclosure statement and what was on it. So because your agent knew, guess what? He was also known. So it was, while the court held that Payne deemed to know everything that the agent knew. Now, this is one that you do want to remember, because you're going to have agents, and I can give you one specifically because I even had a, we'll call it heated discussion with an attorney where similar situation in regards to the imputed knowledge. Because here's what happens. We have in the purchase agreement, in any of them, anytime there's a condo and association, we have to get the condo docs, the association docs. So as a listing agent, we deliver them to who? The buyer or the buyer's agent? The buyer's agent. So based upon this court case, who would then be deemed to have received or have the knowledge that, well, just know that it's fun when you got to fight with an attorney, but keep that one in mind because that is something that courts have found. So in this case, Payne argued that the agent was not actually his agent because he had not signed the buyer's agency agreement. However, the thing that we need to know right here in Michigan is simply this, and this is the way it worked out where this case was from. Michigan law says that a realtor can become someone's agent with all the responsibilities that come with that, even though there's no agency contract. So let me put the key word in there, with all responsibilities and liabilities, even though there is no agency contract. Again, implied agency. So without having a signed contract, we do have and would have all fiduciary responsibilities owed to that individual. So without an agency contract, the realtor may not be able to get paid and will not have the other protections that come with an agency contract, which limits the scope of our responsibilities also. And yet you still would be legally responsible. So what's the lesson? Generally held, the principle of law that knowledge of an agent is imputed to the principal. That means everything I know, my client knows. If a seller listing agreement discloses something to a buyer's agent, the buyer is deemed to know that information regardless of whether or not the agent actually passes it on to the buyer. So the imputed knowledge means that the buyer has no claim against the seller or the listing agent for non-disclosure. If the buyer's agent does not pass along the information, the buyer could certainly, and this is the part that concerns us, the buyer could certainly have a breach of fiduciary duty claim against his or her agent. So if you were in this position, they could make a claim against you. Now, again, it's always a key part is to be able to say that they could have a claim against us. Yeah, Candace, thank you. Yeah, you'll see some things. I actually had to read it twice to make sure I had it correctly. but the wording is a bit tricky on the form, so don't be embarrassed to ask for help or an explanation. So when you do take a look at that, don't be afraid. Talk with your manager, broker, give me a call. All right. Next. Another one for us. Real estate agent knew about a leaky roof. Did we ever have a situation like this? But he did not disclose that information to the buyer, who happened to be a client. The buyer ends up suing the agent for failure to disclose the condition of the leaky roof. And this was the interesting part. The agent's defense was kind of simple, that he had hired someone to fix the roof, and it was reasonable for him to believe that it had been fixed and that there was nothing to disclose. Now, that makes a lot of sense until you know the rest of the story. Yeah, Mr. Cribbs. It's coming back, isn't it? So the court rejected the agent's defense because in this particular case, the person that the agent hired fixed the roof, which was Mr. Cribb, was simply a painter and pressure washer. He was not a licensed contractor. And after completing the work, this is the real part that gets the guy in trouble, not Mr. Cribb, but Mr. Cribb texted the agent that, quote unquote, he may have located the leak, and he hoped that that was it. Reasonable for him to assume that the repair was taken care of? I think not. That was just kind of silly in his case. So what's the lesson from this particular case? As realtors, we should never choose whom somebody's going to hire to have repairs handled. There's ways of doing it, ways of making recommendations. But in this case, Schmuck hired Mr. Cribb himself, and thus we have the issue that we have. Yes, make a recommendation. You may and probably should make a recommendation of a couple of people. It could be, I have Joe Handyman. He's a professional. He's a licensed. I can recommend you him. Doesn't mean you have to use him. I could recommend more to you. I kind of want one, but I do have others I could refer you to. Realtors should never insert themselves in the middle of what should be a conversation between the contractor or inspector and a seller client or buyer client. I don't want to give information that they're going to rely upon. And the key being is that they may misunderstand, mishear. I may leave something out because I'm not a professional. I'm simply relaying information. But here's the key. You're going to be the one who's held responsible for any of the information you relay. So as it's saying here, relaying that information to the client is opening yourself up to a claim that their rendition, your rendition of what information was inaccurate, either intentionally or negligently. You could get yourself in trouble regardless, simply because. Here's a great question. The Clinton's office is in there, and Mr. Finn's probably making burgers out of Blackstone today. But when the listing says BAT/VAI, does the buyer agent take on added responsibility to investigate and notify the buyer? I'm going to say no, because your fiduciary responsibilities haven't changed. Now, here's a quick question. Nobody needs to answer this, but in your own mind, you'll know whether or not you have the answer. What are your fiduciary responsibilities? Like, if I said, here, I already gave one earlier, confidentiality. Do we know the others? If you don't, do you know the acronym to remember them? I'll give you this one, old car. Old car. That should help. Are you ready? Write them down. Obedience, loyalty, disclosure, confidentiality, accountability, reasonable care. Now, I give one other one just for an aspect of, I want to say clarity to reasonable care, which is really what we're dealing with when we see the bot buyer, however you want to say that. Due diligence. See, we owe that to the buyer client. We owe that to a seller client. So when it's there, it's up to us to be able to guide them and provide any knowledge that we do have. That, look, do you have knowledge or do you got a feeling that potentially the square footage is off? Maybe we should measure it. Maybe we should have the buyer measure it. Maybe we should have the appraiser in his report make sure that the buyer checks that. There's a lot of things that go in with that. So when somebody says buyer's agent to verify all information, well, that's what you should do anyway. But it's their way of trying to cover their backside and make sure that nobody can come back against them. I haven't seen anything, any court cases in history, any time that we've gone through any pre-licensed training. I've still not seen anything where being able to put BAT/VAI has covered anything. Bottom line, it's our responsibility whether or not that's stated or not. Great question, guys. I like that. All right. I think I've got one more for you here. All right. No, this is our wrap up, and then we'll see if we got any questions.
By the way, Darwin, that was John Lafferty's question. He wants credit for it.
Wow. And he knew the answer to that. He's like, you know what? This should just be a great point and a great time to cover that. John Lafferty, he's the man. Here's what we're going to take away from today. We'll wrap it all up with this and then see if anybody's got any questions. A buyer's agent can work and get paid for by working with a for sale by owner without creating an agency relationship, simply by using a one-party commission agreement. We know that, by the way, we should avoid dual agency. We should avoid transaction coordinator. If I break into the transaction coordinator anymore, somebody came to you saying, hey, Larry, I need your help. That's probably the person you should represent. You're going to get paid the same amount of money regardless. Make it easier on yourself because you represent someone. Avoid dual agency when you can, and we've talked about that previously. Second point is, as a matter of law, a buyer client is deemed to know everything that his or her agent knows. Imputed knowledge. A licensee can be responsible for a breach of fiduciary duty even in the absence of a written agency agreement, which we should be getting those, and I think we all need to make a practice of trying to get those in place before we write the contract. And I'm not talking that's the first piece of paper that we fill out before we fill out the purchase agreement. I'm saying, let's meet with the buyers, tell them what it is that we do, how we earn our money, where we look for properties, how we look for properties that aren't even on the market, and then ask them to sign a contract. Of course, that's after getting the agency disclosure. Last point for the day. The buyer's agent should always require that the contractor and or the inspector communicate directly with the buyer rather than communicating through you as a buyer's agent. Keep yourself out of that nasty, nasty position. Now, I always say, go talk to people. You guys know that, but let's see, do we have any type of questions as to what we covered today? I'm going to ignore the person in the back. No, I got somebody here, you guys.
How about disclosure regarding?
Hold on a second. I got a question here, Bill. So when does it come into place that communicating to our client wow. So what's the best way to communicate is what I'm hearing. Does it or need to be in writing? Can it be email, text? Can it be verbal? One thing that I learned from a gentleman years ago was OVR, or excuse me, Yeah, AVO, OVR, that's another term that we use in management. AVO, avoid verbal orders. Avoid verbal orders. So if there's something that should be tracked, noted, made part of the file, it's something that's important, put it in writing. Just the communication aspect of it, if nothing else. Email would work. Text could work, because now you've got written history of the communication back and forth. I've got it tracked, but remember this, we're not necessarily talking binding agreements. If we're talking binding signatures, then what we should have is in writing and not just an email. Because remember, the only thing that is binding must be in writing. Signatures must be in writing. So that's a key part for that. Oh, too funny. Bill, if you're, did I get that, Larry, for you?
I was asking about disclosure regarding real estate agency relationships when you do a one side commission.
Clarify that further, Bill. One side of the commission.
The agreement that you talked about at the beginning of the meeting.
Yes,
What was that called?
the one-party commission agreement.
Okay, so when you do that with them, do you need to get a disclosure regarding agency relationship?
Yes.
And then
Because
it says that I'm acting as a what?
buyers, with the scenario as we have it, that would be, I'd be acting as a buyer's agent. And so if we go back to disclosure laws, what we know is it says that we must disclose to all parties to the transaction, a buyer and a seller. So there's those two parties that come together. We've already disclosed to the buyer that we represent them. We have a contract that follows that. We then went over to the seller, said, hey, seller, I'm working with this buyer. They like your house. If they were to decide to buy that, would you pay the commission? We sure would. We go, great. This says that you're going to pay me $295 and 4%. And oh, by the way, remember, I represent the seller, but let me now put it right onto an agency disclosure that in check, buyer's agent. Check, I'm a disclosed buyer's agent, which is the reason we're then going to go, by the way, just a reminder, you might want to consider getting legal counsel because I do represent only the buyer. So, yep, I would have the one-party agreement plus the agency disclosure for both buyer and seller. Yes, sir.
Real quick, if you represent the buyer with a for sale by owner and you provide the seller with the seller's disclosure statement, lead-based paint disclosure, and walk them through how to fill it out, are you doing anything beyond being a buyer's agent?
Wow, great question. I think that's the part where we have to be careful. Because by law, if anybody were to ask us for the statements, my understanding is still we have to provide them. Because that is a form mandated through both state and federal law. For what they do, you know, look, what we say to our own clients when we have a listing is we don't help them fill it out. We give them guidance, direction on how to fill it out. And if they say that, well, you know, 10 years ago, I had a pipe up there in the roof that leaked, and I had a $10,000 insurance claim that I filed. Do I have to say yes, that I've had water? Well, you don't answer that. You pull out the form and let's see, what does the form say? And the form says, is there any evidence of water? Doesn't say where it's coming from. You simply read the question again for them. And then, look, if anything, this is our guidance, disclose, disclose, disclose. It's hard to be in a bad position when you tell people that they should just disclose. However, if it's a really nasty one, here, look, we're not attorneys. You might want to seek legal counsel. If that's a real concern, you don't, but we don't tell them how to fill it out. We guide them, give them direction, but it's up to them as to what they actually do with that. Another great question. I see some in the chat here. Let me pull that. Why not just use notice of buyer agency? Well, you probably could. Great question for Saunders. I'm thinking of that form. It's really, really simple. I would say you'd probably get away with it, but I think the one-party commission agreement is the best way to be able to go, because it's going to cover a number of additional things. And even though the notice of buyer agency, which is, I hate that they call it that. Well, I shouldn't say hate, that's a strong word. I don't like that they call it the notice of buyer agency, because it's really a notice of, you're going to pay me. And by the way, and when we use that form, who's going to pay us? Because whoever's paying us is who should sign that. We're receiving a compensation from the listing broker. The buyer's signature on that form means nothing. If the seller's paying us, then it means that the seller should sign it. Okay. Oh, good stuff, good stuff. Any other questions, guys? Otherwise, I'm showing we're at 12:32.
One more time with the old car acronym.
Old car or old card. Put that D at the end. So obedience, loyalty, disclosure, confidentiality, accountability, reasonable care. And when I add that D on to the end, that just kind of takes reasonable care a little bit further, a little more clarification, but due diligence. But it's old car. You can absolutely use the D if you want to, because that'll help you understand the rest of that. All right. Hey, everybody, another great Tuesday. Next week, we're already set. Mr. Bob DeVore is going to be hosting one of our title partners. And really, I'm going to say going in deeper on a title level, understanding, I believe it's paragraph 17, 21. Anyway, in regards to titles, so Prasanna, that request is going to hit next week. We're going to go in deeper, understanding that paragraph on title insurance, pre-title, the importance of that. And oh, by the way, what the heck do I do when I get the commitment? What should I be looking at, reading? So that's kind of what we want to get into next week. Bob's going to host you with that with one of our title partners. So guys, have a great Tuesday, and we'll see you next week. Go talk to people.